Welcome back to the deep dive. Today, I want you to just picture something with me for a second. We are standing on the edge of this massive digital cliff, and we're looking down at everything we've ever posted online.
Everything.
Everything, every tweet, every blog post, every photo of your cat, every LinkedIn update. And standing right there with us are the biggest AI companies in the world, and they are holding a giant industrial-sized vacuum cleaner.
That is quite the visual. But honestly, it's pretty accurate. We are talking about the Great Scrape.
The Great Scrape. It really does sound like a heist movie, but it's actually the reality of how artificial intelligence is trained. It's early 2026, and this whole debate over whether this mass harvesting of data is legal or, even ethical, it's hitting a fever pitch.
It really is. It is probably the defining privacy debate of our decade. And to help us navigate it, we have this fascinating clash of perspectives today, a real heavyweight fight.
Exactly. So on one side, we've got this major paper by two American legal scholars, Daniel Solove and Woodrow Hartzog, and it's appropriately titled The Great Scrape. They look at this whole situation and they just see a total disaster.
A privacy nightmare.
Yeah, they call it a privacy nightmare.
Strong words. But then on the other side, you've got this rebuttal from Hiromitsu Takagi, a leading Japanese data protection expert. And he's looking at the exact same situation, the same laws, and he's coming to a completely different conclusion.
He's basically saying they're misunderstanding the whole structure of privacy law itself.
That's his whole argument.
So we have the privacy nightmare team versus the you're reading the rules wrong team. And the backdrop here isn't just academic theory. I mean, this is happening in the real world. Japan is reviewing its own laws right now to decide how to handle AI.
Exactly. So our mission for this deep dive is to move past that surface-level shouting match of AI versus privacy. We want to see if we can figure out the structural purpose of these laws. Does scraping your data actually harm you, or are we just applying old rules to a new game?
Okay, let's get into it. Let's start with the nightmare scenario. Solove and Hartzog. What is their main beef with scraping? Because to the average person, scraping just sounds like copying and pasting.
Well, it is, but it's copying and pasting on a scale that's it's hard to even comprehend. So Solove and Hartzog's argument is built on what we call FIPPs.
Right, the Fair Information Practice Principles.
Yeah. Think of them as like the 10 Commandments of privacy law. They're the foundation of GDPR in Europe and most privacy frameworks around the world.
The golden rules. So what are we talking about here?
We're talking about fairness, transparency, consent, purpose limitation, data minimization, all these concepts designed to give you control over your digital life.
Okay, and how does AI scraping stack up against these commandments?
Oh, poorly. So poorly. So Solove and Hartzog basically go down this list like a teacher grading a test. And for AI scraping, they just mark fail on almost every single one. I think they list 8 specific violations.
Right. That is a failing report card. Let's dig into a couple of them.
Okay, so take transparency. The principle says you should know when your data is being collected. But did OpenAI or Google or Anthropic send you an email saying they were taking your specific blog post to train a chatbot?
No. I found out on the news, just like everyone else.
Right, so transparency, fail. Then there's consent. Did they ask for permission?
Definitely not.
Consent, fail. And then look at purpose limitation. This principle says data collected for one reason shouldn't be used for a totally different reason. You wrote that post to, I don't know, share a recipe.
Right, not to help build a neural network that might one day take my job.
Yeah.
The context is just gone.
It's completely stripped away. And the big one, which we'll come back to, is data minimization. The law usually says companies should only collect the minimum amount of data they need. But AI models, they're data hungry. They want everything, the whole internet.
So their conclusion is pretty stark then.
Yeah, they basically say if you follow the letter of the law, mass scraping is illegal, period.
So, case closed. Shut it all down.
Well, this is where it gets really interesting and, honestly, a little bit contradictory. Despite saying it violates everything, Solove and Hartzog admit that a total ban it's impossible.
Wait, why? If it's a nightmare and it's illegal, why can't we just ban it?
The economy. They argue it would kill innovation. Solove even calls the AI boom a bubble in one video. He's pretty skeptical, but he acknowledges that bursting that bubble would wreck the economy.
So it's a classic too big to fail situation. We've built our economy on a crime, so we just have to let the crime continue.
That's the dilemma they're in. So they propose something they call the Great Reconciliation.
The Great Reconciliation sounds very grand. like a peace treaty.
It is. It's a compromise. They suggest that instead of a ban, we allow scraping, but only if it serves a public interest. They want to treat it like we treat government surveillance.
Surveillance, that's a heavy word to use there.
It is, but it fits their view. Surveillance is invasive, it's dangerous, and it's usually illegal unless the government has a really, really good reason.
Like national security.
Right. So Solove is saying we should treat AI the same way. It's a sin, but we'll forgive it if you can prove you're doing something incredibly valuable for society.
But who decides that? Who decides if, a funny chatbot is in the public interest?
That is the million-dollar question. And it's this ambiguity that Hiromitsu Takagi just jumps all over. He steps in and says, hold on a minute. We don't need a reconciliation because there was never a war to begin with.
Okay, so let's bring in Takagi. He's got this hierarchical data protection theory. It sounds incredibly academic.
It does sound a bit dry, but it's actually really intuitive once you break it down. Takagi argues that Solove and Hartzog are making a fundamental mistake. They're treating those principles, consent, transparency, like a flat checklist.
But aren't they a checklist? You just call them the 10 Commandments?
Takagi says no. He says it's a hierarchy, a pyramid. At the very top, you have the core protection interest. This is the goal, the whole reason the law exists.
And what is that goal?
To ensure appropriate evaluation and decision-making about individuals.
Okay, let's pause on that. Decision-making. So we're talking about things that actually affect my life.
Exactly. The law exists to stop people from using your data to unfairly judge you, to deny you a loan, to reject your job application, to jack up your insurance premiums. That is the core. That's the harm we're trying to prevent.
Got it. So the goal isn't just secrecy, it's fairness.
Precisely. Now, below that top layer of the pyramid, you have what he calls instrumental interests. These are the tools: consent, purpose limitation, access rights.
So consent is just a tool?
It's a tool to achieve the goal. It is not the goal itself. And this is Takagi's key insight. If the core interest isn't threatened, if nobody's making a decision about you specifically, then you might not need the tools.
I think I see. So if an AI is just reading my blog to learn how sentences are put together, but it's not deciding whether or not to give me a mortgage,
then the instrumental interest of consent might be totally unnecessary. Takagi calls this non-decision use. He says AI training is almost always non-decision use. The AI is learning patterns from the collective, not judging the individual.
Wow, that is a huge distinction. So Love sees data collection as the crime.
Yes.
And Takagi sees unfair decision-making as the crime.
You've got it. That's the whole disagreement in a nutshell. Takagi uses a great analogy with copyright law. You know how you can use a book for information analysis?
Yeah, fair use.
Hey.
Like for research.
Right. As long as you aren't just photocopying the book and selling it, you can use it to learn. Takagi says data privacy should be seen in a similar way. Using personal data to learn patterns is different from using it to judge a person.
This really flips the whole script on data minimization, doesn't it? Because Solove's big complaint was that AI companies are just hoarding data.
It completely reframes it. And this is where Takagi brings in a bit of a history lesson. We have to go back to the dusty archives of the 1960s and 70s.
I love a good history lesson.
So we're looking at these foundational privacy reports from the RAND Institute and so on. Back then, the concept wasn't collect as little as possible. It was relevancy.
Relevancy.
Yes. The rule was that data had to be relevant to the decision being made. So if you're deciding on a loan, someone's medical history is probably irrelevant.
Right. You minimize the data to keep the decision fair and unbiased.
Exactly. But over time, especially with the European GDPR, the label just sort of shifted from relevant to data minimization. And Takagi argues this little semantic change caused massive confusion. People started thinking it meant minimize the volume.
But the original intent was minimize irrelevance.
Correct. And if you aren't making a decision,
then there's nothing for the data to be relevant to.
You got it. If you're training an AI to understand human language, all human language is relevant. There's no specific decision to measure against.
So Takagi is basically saying Solove is trying to call offside in a game of tennis. He's applying a rule that just doesn't fit.
That's a good way to put it, yes. And here's the most ironic part of this whole thing.
Go on.
Solove himself actually brings up an old U.S. law, the Fair Credit Reporting Act, the FCRA. He praises it.
What does he like about it?
He says it has wisdom because it's use-based. Yeah. It only kicks in if you use data for specific things: credit, employment, or insurance.
Wait a minute. Isn't that exactly what Takagi is saying?
It's the ultimate irony. Takagi points this out. The FCRA is a perfect real-world example of his hierarchical theory. It regulates decision use.
So if Solove likes the FCRA, he should logically agree that scraping itself isn't the problem.
The problem is only if the data is then used to make these high-stakes decisions about people, which is why the Clearview AI example is so important here.
Right, the facial recognition company. Solove kind of lumps them in with ChatGPT. They're all just scrapers.
But Takagi says they are fundamentally different. Clearview is building a database to identify specific people. That is 100% decision use. That should be heavily regulated.
Whereas ChatGPT.
Is learning about language. It's non-decision use. It's not building a file on you to deny you a visa. So applying strict consent rules there just creates a bottleneck for no real protective reason.
It's the difference between a tool for judging and a tool for learning. But this brings us back to that whole political situation.
It does. Solove mentions that incident with the Italian Data Protection Authority. A while back, they briefly banned ChatGPT, but then they reversed course.
And Solove calls that a walk back. He kind of implies the regulators were pressured, right? He says no one wants to say no to AI.
Exactly. He sees it as a failure of political will. The AI bubble is too big to pop, so the regulators caved. But Takagi offers a completely different take.
What's his interpretation?
Maybe the walk back happened because the regulators realized that legally they didn't have a leg to stand on.
Because training an AI doesn't actually violate the core purpose of the law.
Precisely. If the law is about preventing unfair decisions and the AI is just training on patterns, then the privacy nightmare might just be a bad dream caused by misreading the law.
So Solove thinks the regulators caved to pressure. Takagi thinks the regulators actually, read the manual.
It's a harsh way to put it, but yes, that's the split. Takagi's approach offers a concrete legal line. Is it for decision use or non-decision use? It's a hard yes or no. Solove's public interest solution is just a fuzzy maybe.
This is fascinating because it totally changes how we should feel about our data. I think most of us, you included, feel a little weird and creepy about AI knowing things about us.
Absolutely.
And Solove validates that feeling. He says, yes, that creepiness is a rights violation. He frames it as surveillance.
And surveillance is inherently oppressive. He validates that emotional response that my data is mine.
But Takagi is essentially saying, get over the creepiness and focus on the actual harm.
He is. He argues that the creepiness isn't the legal injury. The injury happens if that data is used to deny you a job or to redline your neighborhood. By focusing only on the collection, the scrape, we're fighting the wrong battle.
Okay, so what does this all mean for you, the listener? Why should you care about this debate?
Because it changes what you demand from your government. If you demand stop collecting my data, you might be asking for the impossible. You might break the internet in the process.
Right. It's like demanding that nobody can look at you when you walk down the street. It's just not feasible.
But if you demand stop using my data to unfairly judge me, that is a battle you can actually win. And it's the battle that protects your life and your livelihood.
That's the so what right there.
Yeah.
Stop worrying so much about the vacuum cleaner. Worry about what they build with the dust they collect.
I couldn't have put it better myself. The genie is out of the bottle. The question now is, do we try to shove it back in with laws that don't really fit, or do we teach the genie some manners?
Teaching the genie manners. I like that.
Takagi's approach is about manners rules for how decisions get made. Solove's approach is more about trying to cork the bottle because he's afraid of what the genie might do.
Well, I want to leave everyone with a final thought on this. We've been talking about privacy as a kind of shield, something to hide behind. Don't look at me. But if Takagi is right, maybe privacy should be a sword.
A way to challenge the decisions made about us. A powerful shift.
If we ban scraping to protect privacy, do we inadvertently kill our ability to analyze history, to conduct research, or train useful tools, all to protect a right to not be analyzed that the law may have never intended to give us?
It really forces us to ask, is the goal of privacy to be alone, or is it to be treated fairly in a crowded world?
That's the question for 2026. Solove says, leave me alone. Takagi says, treat me fairly.
And the laws we write today will decide which one of those futures we get to live in.
A huge thank you to Hiromitsu Takagi's blog and the Solove and Hartzog paper for giving us this brain twister today. We'll be watching very closely to see how the Japanese legal review pans out.
It might just set the standard for the rest of the world.
Until next time, keep diving deep.